there is some more breaking news in the Sean Diddy Combs federal trial. Diddy has abandoned his bail request. He filed an appeal previously of the federal court's decision to deny him pretrial release pending his trial, and he has now abandoned officially that request for to be released on bail. His attorneys have filed now a motion to dismiss this appeal, and I want to go over this in detail with you, friends. Basically, today, as we basically on Friday, news outlets have reported that Sean Diddy Combs abandoned his final avenue for pursuing bail amid his racketeering and sex trafficking charges on Friday. He agreed to remain jailed through his scheduled May 2025 trial in New York federal court. So Sean Diddy Combs will be going to a jury trial in May before a New York federal jury. Combs filed a motion to drop his appeal of the pretrial detention order that has had him jailed at Brooklyn's Metropolitan Detention Center since his September indictment, which alleges that the hip-hop star used his vast media empire to traffic and abuse women for more than a decade. So Sean Diddy Combs has tried numerous times to go free pending trial on a $50 million bond, most recently suggesting that he could be subject to home detention and secure the package with multiple family members' signatures. But a slew of different judges have rejected his requests for pretrial release, culminating late November with U.S. District Judge Arun Subramanian's finding that he's a danger to the community. Combs has appeared to accept Judge Subramanian's decision on Friday as he opted to close his Second Circuit detention appeal. So news outlets have reported that Mr. Combs does not seek to appeal the district court's denial of his renewed motion and hereby moves to voluntarily dismiss the appeal. His lawyers wrote to the Second Circuit on Friday. Combs personally signed a declaration confirming that he understands the effects of the dismissal motion, that is, that he will likely remain jailed through his jury trial scheduled to begin May 5th. A spokesperson for the government declined to comment on this dismissal on Friday. Lawyers for Combs did not immediately respond to a request for comment on Friday. This musician maintains his innocence and has vigorously litigated the case since his arrest in September, most recently alleging that prosecutors orchestrated an outrageous seizure of privileged notes from his jail cell. The government denies any impropriety related to the jail cell search. Judge Subramanian ordered prosecutors last month to delete their photographs of Combs' notes for the time being. Meanwhile, Combs continues to be flooded with civil assault lawsuits from alleged victims claiming that he assaulted them. The civil litigation onslaught has also pulled in fellow celebrity Sean Jay-Z Carter, who denies participating in Combs' alleged wrongdoing and says that he's being extorted by the alleged victim's attorney, Tony Busby. And Jay-Z, we've covered this on numerous other lives and videos on this channel. Jay-Z has filed an extortion lawsuit and an intentional infliction of emotional distress lawsuit against Tony Busby. The government is represented by Maureen Comey, Meredith Foster, Emily A. Johnson, Madison Reddick Snyder, Christy Slavic, Mitzi Steiner, and a number of other attorneys. The U.S. Attorney's Office for the Southern District of New York, where Sean Diddy Combs is represented by Mark Agnafila and Tina Garagos of Agafilo in Trader LLP, and a number of other firms that have joined. So this is the case U.S. v. Combs. And this is a really significant situation, my friends, because as we have covered on this channel, Sean Combs has tried on multiple occasions to be released pending his trial. He will be subject to a jury trial in federal court in May, starting May 5th of 2025. And he just recently filed this motion to dismiss his appeal voluntarily. And we're going to go through this motion right now. It says, pursuant to federal rule of appellate procedure and local rule, Sean Combs moves to voluntarily dismiss the appeal. This is an appeal from the District Court September 18th, 2024 order denying pretrial release on conditions and ordering Mr. Combs detained pending trial. Mr. Combs filed his notice of appeal on September 30th, 2024, and filed a motion for bail in this court on October 8th, 2024. On October 17th, 2024, Mr. Combs filed a motion to hold the appeal in abeyance pending a renewed motion for bail before the district court. The court granted the abeyance motion on October 24th, 2024. On November 8th, 2024, Mr. Combs filed his renewed motion for bail before the district court. On November 27th, 2024, the district court denied Mr. Combs' renewed motion. Mr. Combs does not seek to appeal the district court's denial of his renewed motion and hereby moves to voluntarily dismiss the appeal. Counsel has explained the effect of voluntary dismissal of the appeal, and Mr. Combs' signed local rule 42.2 statement is attached here too. So essentially, Sean Combs, that's interesting. Let's look at his signature here. So Sean Combs has signed a voluntary statement that he understands the effect of dismissing the appeal voluntarily. It likely means that he will remain jailed until his May 5th, 2025 trial begins in federal court. Let's look at that signature there. That is Sean Combs' signature. And yeah, I mean, it does look like the Sean John emblem, actually. It does look like his signature, but that's interesting. So pursuant to local rule 42.2, and in support of appellant Sean Combs' motion to voluntarily dismiss the appeal, Mr. Combs hereby states that A, counsel has explained the effect of voluntary dismissal of the appeal. B, he understands counsel's explanation. And C, he desires to withdraw and voluntarily dismiss the appeal. So what's likely happening here is that it costs money to litigate an appeal. Appeals are very expensive. So what's probably happening is that Sean Combs is trying to make economic decisions about where to spend his money. Does he want to spend money fighting this appeal and once again have it denied, where he's already been denied by several different federal judges? He probably wants to focus his time, energy, and money on preparing for his trial. He's raised a number of different arguments, including his argument that he cannot adequately prepare for his trial while within the confines of the Metropolitan Detention Center. Judge Subramanian did not find that persuasive. He said that he does not feel that Sean Combs would not be able to prepare adequately for trial. We also could pull up the order where the federal judge in November denied Sean Combs' bail request. And I want to go through this with you, friends, because this is very significant. This is what Sean Combs is saying. I accept this. I accept the fact that the judge ruled in this way, and I'm not going to continue to fight this battle here. So there was an order entered on this docket. Judge Arun Subramanian, United States District Judge, he denied defendant Sean Combs' renewed motion for bail on November 8th, 2024. The court held a hearing on November 22nd, 2024, and the parties filed supplemental letters on November 25 and 26, 2024. And for the following reasons, Sean Combs' motion is denied. So the judge found that no condition or combination of conditions will reasonably assure the safety of the community. So in essence, the court has found that Sean Diddy Combs is a danger to the community and that he cannot be released on bail. It would be essentially too dangerous to the community. So I'm going to go here. First of all, we have covered on our channel a number of videos, a number of lives that talk about details of the Sean Diddy case. He's facing federal charges. He's also facing a lot of civil lawsuits right now. So he is in a lot of hot water, friends. There's a lot of heat on him right now. So the court has evaluated each of the factors that it must consider, the nature and circumstances of the offense charged, the weight of the evidence against the person, the history and characteristics of the person, and the nature and seriousness of the danger that would be posed by the person's release. So these are the factors that the court must consider when they're deciding whether to release a criminal defendant pending their trial. Courts have broad discretion. They have a lot of ability to make decisions in weighing these factors. The court has also reviewed the information submitted by Combs and the government across all of these bail hearings in this case. The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community. In support of this finding, the court provides the following reasons. Number one, a rebuttable presumption of detention applies to this case. Even if Combs successfully rebuts this presumption, which the court assumes here, it remains one of the factors that the court considers in determining whether the government has met its burden of persuasion. So if we talk about this for a second, there's certain things in the law called rebuttable presumptions. And sometimes in the law, there are certain burdens that fall on one of the respective parties, where there is a presumption that is made and that the court is entitled to make a presumption, and then the burden falls on that party to rebut that presumption. And that's what the court is referring to here. So next, we have some redacted pieces to this order that the judge issued. The indictment charges Combs with serious and violent crimes. It alleges that for decades, Combs abused, threatened, and coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, forced labor, kidnapping, arson, bribery, obstruction of justice, etc. It says that Combs himself carried or brandished firearms to intimidate and threaten others, including victims of and witnesses to his abuse. And notes that during searches of Combs' residences in March 2024, law enforcement seized firearms and ammunition, including 3 AR-15s with defaced serial numbers, as well as a drum magazine. When Combs' authority or reputation was threatened, the indictment alleges, he and members of his enterprise engaged in acts of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence included kidnapping and arson. The indictment also charges Combs with a crime in violation of federal law, requiring the court to consider the nature and circumstances of the offenses charged, including whether the offense is a crime of violence, whether it is a violation of Section 1591, and whether it involves a controlled substance or firearm. The government so the court also found that the government has presented direct evidence of Combs' violence. This includes video footage from 2016. There is clearly violence even in the version of the footage that was submitted by Combs, and text messages between Combs and victim 1. Text messages from the hours and days following the 2016 Intercontinental Hotel incident. Quote, "I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising." And then there's some redactions here. Nevertheless, Combs argues that the weight of the evidence does not support a charge of a violation of that particular federal law. In his view, it supports, at best, a toxic, sometimes violent long-term relationship between Combs and victim 1. But regardless of whether that's true, there is compelling evidence of Combs' propensity for violence. So these are the court's findings in its order when the judge is denying Sean Combs bail. The court also found there is evidence supporting a serious risk of witness tampering. For example, Combs initiated and had unexplained communications with witness one, who was subpoenaed to testify before the grand jury in June of 2024, and in fact testified on July 25, 2024. Combs was represented by counsel during this time, and they had offered an explanation for some of these communications, but they could not explain them all. For instance, Combs' efforts to call and text victim one even after his grand jury testimony, or Combs' deleted texts with the witness. Quote, although the phone records confirm that the defendant using a particular phone number and witness one exchanged multiple text messages from June 2024 through August 2024, there were no such messages recovered from Combs' cell phone associated with that number. Further, Combs' interactions with witness one are directly in conflict with defense counsel's representations to Judge Carter on September 18, 2024. The Combs, quote, did not reach out to grand jury witnesses. He didn't do it and he wouldn't do it. So essentially, the court is saying that there's evidence here that Combs has tampered with witnesses or was trying to influence witnesses, and that he's had communications with witnesses, but then the implication is that he then deleted that evidence because no such text messages from that number were recovered from his phone, etc., etc. So moving forward, back to this order of the judge. The judge also found there's evidence that Combs violated Bureau of Prisons regulations during his pretrial detention to obscure his communications with third parties. He paid other inmates to use their phone access code numbers to take calls to those not on his approved contact list. Instructed family members and defense counsel to add other people to three-way calls so that their communications were more difficult to trace, and used a messaging program called Contact Me ASAP. Although the court recognizes that the parties dispute whether Contact Me ASAP is permitted or not. You know, Combs' attorneys, I recall seeing this in another article, Combs' attorneys had alleged that they did not have any reason to believe that Contact Me ASAP was a prohibited form of contact in the prisons. In fact, they said that this is actually a very commonly used form of communication, they're alleging, this messaging program. So then the court, the federal judge, found that the government gives examples of Combs' communications utilizing these means from as recently as November 4th, 2024, directed to efforts to influence the jury pool or to reach out to potential witnesses. The court makes no determination that the content of Combs' communications through these channels was improper. However, his willingness to skirt Bureau of Prison rules in a way that would make it more difficult for his communications to be monitored is strong evidence that the court cannot be reasonably assured as to the sufficiency of any conditions of release, especially given that they occurred when Combs was seeking bail and when he knew the government's concerns about witness tampering and obstruction were front and center. So basically, the judge is saying, Judge Subramanian is saying, Combs was willing to do these acts, which are arguably evasive, even when he knew the government was watching, even though he knew that he was front and center requesting bail. So that's pretty ballsy, is what the court is saying. So they're saying we don't know if the contents were wrongful. We don't know if the contents were prohibited, but we do know that he was trying to use certain methods that would make it more difficult for the Bureau of Prisons to detect who he was talking to. There are other descriptions of Combs as a, quote, serial obstructor, citing obstruction as a primary reason for seeking detention. So underscoring the court's concern, despite defense counsel's assurances to the court at the November 22nd, 2024 hearing with Combs in attendance, that Combs stopped using Contact Me ASAP as of November 16th, 2024, the government indicates that Combs has continued to use this messaging service as recently as this past Sunday, November 24th, 2024. That's another finding that this court made. The court further notes that it held an emergency hearing on November 19th, 2024 to address the government's usage of notes on legal pads recovered from Combs' bank during a sweep of the Metropolitan Detention Center. At that hearing, defense counsel advised, quote, all these legal pads say legal. Yes, yes, they're marked as legal. After the hearing, the court inquired why, in light of counsel's representation that the notes at issue were on legal pads that were clearly marked as legal, photographs taken during the sweep show no such labels. At the November 22nd, 2024 hearing, defense counsel admitted, quote, it has to be the case that as of the day of the search, legal wasn't written on every legal pad, and that they were not sure whether the pad presented to the court had legal on it at the time of the sweep. The circumstance of this incident and the misrepresentations made at the November 19, 2024 hearing where Combs was present bear on whether the court can be reasonably assured that any conditions it imposes will be followed, or whether through inadvertent or active subversion they will be broken and the community's safety threatened. So the court is essentially saying we can't trust Sean Combs or even maybe his lawyers to abide by any of the proposed bail terms. This is Judge Subramanian denying his request. Now I'm going to go to the next page and show you what else he wrote. The judge then continued on to say, the court assumes that it may consider the bail package that Combs has proposed. The court assumes that it may consider the bail package that Combs has proposed. However, given the nature of the allegations in this case and the information provided by the government, the court doubts the sufficiency of any conditions that place trust in Combs and individuals in his employ, like a private security detail, to follow those conditions. Finally, the facts and circumstances here differ from those in Combs' principal cited authorities. So principal cited authorities means the case law, the cases that Combs' attorneys are citing to rely upon, that they're trying to use to persuade the court to release, that they were trying to use to persuade the court to release him on bail. So the court says, the court distinguishes all these authorities and says, for example, in the United States v. Fox, the Second Circuit recognized the case presented an extremely close call and that any loosening of conditions or more compelling evidence presented by the government could well tip the balance in favor of pretrial detention. But in Fox, the Second Circuit did not address a risk of obstruction, and the government failed to engage with the proposed bail restrictions. In the United States v. Jeffries, while the government raised danger, its principal concern with respect to defendant Michael Jeffries was flight. He had no criminal history. The alleged criminal conduct, which did not involve the kind of violence or RICO allegations alleged against Sean Combs here, abated nearly a decade ago, and Jeffries was 80 years old. Combs' motion for temporary release is denied. The court also finds that Combs has not shown that a temporary release from detention is warranted. Under this provision, a judicial officer may permit the temporary release of the person in the custody of a United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Combs' application is based on the conditions at the Metropolitan Detention Center, which he says, quote, make trial preparation impossible. But given Combs' access to counsel and documents, there was an issue with Combs receiving a laptop for the purposes of reviewing discovery, but the court addressed that. The firm deadline for the government's discovery, the end of this year, and the time left before trial, over 5 months, Combs has not carried his burden of demonstrating that release from detention is necessary for trial preparation purposes. But the court will properly address any issue that arises with respect to Combs' trial preparation. And if the circumstances materially change, he may renew his application. The motion is denied. The clerk of court is respectfully directed to terminate docket 60. So that is the federal court's most recent ruling denying Sean Combs bail and denying him pretrial release. Sean Combs' attorneys made the argument that he could not adequately prepare for trial while he was within the confines of the Metropolitan Detention Center. And the court said, no, we find that he has access to counsel. He has access to documents. He has access to a laptop now to review discovery. We do not feel that there is sufficient burden on him that would, obstruct his constitutional rights to be able to prepare adequately for his trial. And he's got a number of months before his May 5th, 2025 trial begins. He can prepare from the confines of the Metropolitan Detention Center. So, friends, this is very, very important because Sean Combs officially has withdrawn his appeal, and he seems to be accepting the decision of the federal court. He has agreed to voluntarily dismiss the appeal of the denial of his pretrial, release. And he has essentially said that he understands the consequences to this. He understands that this will likely mean that he's going to remain jailed pending his May 5th, 2025 trial. So, friends, like I said, it seems like Sean Combs is being faced with decisions where he has an expensive, long, lengthy trial. He has mounting legal fees because he's being sued all over the place by a slew of civil litigants who are claiming to be his victims. They're bringing civil suits against him, seeking monetary damages. He has the federal criminal case, the criminal prosecution and charges against him for racketeering, RICO claims, alleged sex trafficking. These are some very serious charges. He's facing a lot of very serious consequences if he's found guilty in the federal criminal trial. So he's probably having to make some really hard choices about where to spend his money. And I suspect that that's why he agreed to voluntarily dismiss his appeal of the judge's denial of his bail request, because that's not really a fight worth fighting right now. He's got other things to spend his money on. And the courts have been very firm. They have found that he's a danger to the community. They have found that they feel he would likely obstruct justice, tamper with witnesses. They do not feel that he would comply with pretrial release conditions. So they have been firm and staunch in their denials. And Sean Combs is probably just like, look, I don't want to keep fighting this. I've got bigger fish to fry. The other thing I wanted to mention is that there is this extensive brief that was filed by Sean Combs' attorneys that very much detailed his prior requests for bail. They were proposing a very extensive package that would be like a $50 million bail package with release terms where he would have 24/7 surveillance of him. It says, Mr. Sean Combs, through his counsel, renews his motion for release pending trial. This renewed motion is based on a significantly updated proposed bail package, new evidence, as well as changed circumstances regarding Mr. Combs' ability to prepare for trial while he's detained. First, Mr. Combs proposes an updated bail package that is far more robust than the previous proposal, as well as other bail packages routinely approved by courts in the circuit. The proposed package even surpasses a bail package recently requested by the government in a comparable case in a neighboring district. The updated proposed conditions, which include home detention with a strict 24/7 security monitoring arrangement and near total restrictions on Mr. Combs' ability to contact individuals other than counsel, will reasonably assure the appearance of Mr. Combs as required and the safety of any other person in the community. Second, new evidence received in discovery from the government undermines the primary basis on which the government initially sought and Judge Carter ordered detention. The evidence makes clear that the government's case is thin. It confirms the defense's initial description of the events depicted in the March 2016 video recording. The video is not evidence of a covered freak-off, but rather a minute-long glimpse into a complex but decade-long consensual relationship between Mr. Combs and victim one. Additionally, the new evidence refutes the government's proffer at the initial hearing regarding a potential second alleged victim. And the new evidence confirms that the government's obstruction and witness tampering allegations of the initial bail hearings lacked a factual basis. Third, Mr. Combs' current conditions of confinement infringe his constitutional rights to participate in his defense. Given the government's amended estimate of the amount of discovery in this case and its unique format, including voluminous video and photographic evidence, Mr. Combs' release on the proposed condition is necessary so that he can review the discovery and prepare for trial. Despite the Metropolitan Detention Center's best efforts to facilitate Sean Combs' team's needs, the current arrangement makes trial preparation impossible, as evidenced by the recent multi-agency sweep of the facility and resulting lockdown. The Bail Reform Act and the Constitution demand more, and therefore Mr. Combs moves to reopen the prior detention decision and requests a release on the proposed updated conditions detailed herein. So Sean Combs' attorneys wrote an extensive brief asking for a very comprehensive bail package. Look at how lengthy this is, friends. It sets forth the conditions of bail that they had felt would be sufficient to persuade the court to release him. It was not sufficient, and several judges have denied his request. And just recently, Sean Combs has filed a voluntary dismissal of his appeal of their decision, the most recent decision, and he has seemed to accept his fate and accept that he will be remaining in prison until his trial in May. So the proposed updated conditions of release are sufficient. They said that he will post a $50 million bond co-signed by Mr. Combs, his mother, his sister, the mother of his oldest daughter, the mother of his youngest daughter, and his 3 adult sons. Secured by the equity in Mr. Combs' residence that's located in Miami, Florida, an unencumbered property appraised at about $48 million. Further secured by the equity of Mr. Combs' mother's home in Miami, Florida. The second condition for bail that Diddy's lawyers proposed was full home detention at his residence in Miami or at a suitable location in New York with GPS monitoring. Counsel will travel to this location for any in-person meetings with Mr. Combs or have counsel meetings via video. To the extent Mr. Combs' travel is necessary to attend court or pre-approved medical appointments, his travel will be restricted to the southern and eastern districts of New York and the southern district of Florida. Mr. Combs must pay all or part of the cost of location monitoring. The third condition for bail that his attorneys proposed was 24/7 monitoring by qualified security personnel approved by the government and pretrial services. The fourth condition that his attorneys had proposed, which have all been rejected by the court, but the fourth condition that they proposed was that Mr. Combs will have no access to telephones or the internet except for during calls with counsel to be arranged by security personnel. Number 5, restrict all visitors except for counsel and a pre-approved list only consisting of specific family members. With the consent of pretrial services and the government, family visits will be scheduled only with pretrial services prior approval. Security personnel will monitor family visits. Number 6, Mr. Combs shall avoid all contact directly or indirectly with any person who is or may be a victim or witness in the investigation or prosecution. Because remember, one of the court's and the prosecution's main concerns is that he's going to tamper with witnesses and try to influence improperly people who are critical to the trial. Number 7, Mr. Combs will consent to provide pretrial services random access to the residence. Mr. Combs' passport was surrendered to his counsel on April 1st, 2024, which counsel will provide to pretrial services. The following family members have also already surrendered their passports to counsel, who will provide them to pretrial services: Janice Combs, Chancey Combs, Jesse Combs, Chance Combs, Jesse Combs, and Delilah Combs. Council number 9, council will continue efforts to sell Mr. Combs' airplane. Oh my gosh. Efforts to sell his airplane. Wow. Number 10, the defendant shall submit to testing for a prohibited substance if required by the pretrial services office or supervising officer. Testing may be used with random frequency and may include urine testing, the wearing of a sweat patch, a remote alcohol testing system, and or any form of prohibitive substance screening or testing. The defendant must not attempt to obstruct, or tamper with the efficiency and accuracy of prohibited substance screening or testing. So that's really interesting. I didn't realize until reading through this that there was such a concern about substance abuse. Number 11, Sean Combs' attorneys had said that Mr. Combs must participate in a program or counseling if directed by the pretrial services office or supervising officer. 12, all other standard conditions of pretrial release. And additionally, for the avoidance of any doubt, and as stated during the September 18, 2024 hearing, if Your Honor wants something more or different, we can do whatever Your Honor thinks is necessary regarding release conditions. These proposed conditions present an extremely substantial, comprehensive bail package for any defendant and are plainly sufficient to warrant pretrial release, argued Sean's counsel. For example, the Second Circuit did affirm the release on similar but far less restrictive conditions of a defendant who was charged in multiple counts, including drug trafficking, firearm, sex trafficking, and related offenses in the case United States v. Fox. So they're citing to this case U.S. v. Fox, saying, hey, this is a similar case. You need to give our guy similar treatment. So the court, essentially, the most important things, friends, to know is that the court on November 27, 2024, denied Sean Combs' comprehensive bail package for $50 million bond and all of those conditions that we just went over. Judge Subramanian, in this order, denied Sean's request. They found that he is a danger to the community. The court found that he's likely to obstruct justice if they release him. He's likely to try to tamper with witnesses and improperly influence them. And they say that he is not believed to be willing or able to comply with the conditions set forth for pretrial release. So Judge Aru Subramanian has denied him. He's the third or fourth judge now to deny Sean's bail request. And so just recently, the new news is on Friday, Sean Diddy Combs has officially withdrawn his request he has withdrawn his appeal. He had appealed the judge's decision that denied him pretrial release. And now in this motion to dismiss that was filed on behalf of him by his counsel, he has now formally moved to dismiss the appeal. And he says, I'm going to focus on other things. I'm not going to continue to fight this fight. And he signed a voluntary statement at the end. You can see this is his signature down here on the bottom right-hand corner. He signed a voluntary statement saying that he understands the effect of abandoning the appeal will have. It likely will mean that he's going to remain jailed in Brooklyn and Metropolitan Detention Center until his trial. So listen, Sean Combs has a number of other fish to fry. He has civil lawsuits coming out of the woodworks against him. He has this federal criminal prosecution. He has so many other things to be spending money on. I believe that's one of the reasons why he decided to voluntarily dismiss the appeal of the pretrial detention, because all of the federal judges that have denied his request have been very firm and given a number of reasons for why they are denying his request. Look at this. The most recent federal judge issued this single-spaced 5-page order that lists all the reasons why he is denying Sean Combs pretrial release. He finds that it does not make it impossible for Sean Combs to prepare for trial while in the confines of the Metropolitan Detention Center. We saw the comprehensive bail package that Sean Combs' attorneys had tried to persuade the court with, $50 million bonds secured by all of these residencies, 24/7 surveillance, GPS monitoring, All family members surrendered their passport. All of these family members surrendered their passport. Sean Combs had agreed to surrender his passport. He agreed to have no telephone or internet access except for counsel. He agreed to have his family visits monitored. There was 12 different conditions here, and the court found that none of it was sufficient and none of it was likely to mean that he would comply with pretrial conditions. So friends, I wanted to let you know I've loved joining you on the second live today. I come to you live every day on this channel, so please subscribe to support the channel. And we are going to come back to you live later on this evening with some additional news that has come out today. I am following every day. I'm following and we're reporting to you live the daily news on the Sean Diddy case, the Jay-Z case. We just did a live earlier today on the Jay-Z's lawsuit against Tony Busby, who represents the woman who's accusing Jay-Z of being involved with one of the offenses that Sean Combs is allegedly involved with. So let's go ahead, friends. Hit the subscribe button if you want to be notified of all of our daily live streams. And I look forward to seeing you guys back here again later tonight for more breaking news. Have a good night, everyone. I'll see you soon.